Mega Motion's day in court is finally upon us. It's been so long since Attorney Bederow filed this 88-page leviathan of a motion to dismiss that I feel like we need to review it so that we'll be bright-eyed and bushy-tailed for Monday's hearing, especially since the hearing will likely take place at warp speed because the judge has restricted each side to just 30 minutes to present their perspective. Granted, on its face, it's pretty dang simple. When was the last time that someone with criminal intent brought along a cameraman to capture his crime spree on video and then broadcast it as far and as wide as the message will travel? Didn't Aidan say that they contacted each of the rolling rally destinations in advance to give them a heads up? Which is part of why almost all of them made arrangements to be elsewhere that day. And didn't Aidan contact the Canton Police Department to give them a heads up? Yet, the police took no action, literally no supervisory role or even assistance with directing traffic. In my book, this feels less like witness intimidation and more like, at best, negligence or worse, entrapment. Look, anyone can read the 88-page motion. You might have heard 6 different creators read it so far, but sometimes we space out during legal documents, even when they're finely crafted with finesse, as Attorney Bederow tends to do. So I've decided to take a different approach by breaking it down and rebuilding it into 6 easier-to-understand sections. Before we swan dive into the emails, the text messages, the allegations of edited evidence, and everything else contained in this motion, we need to answer one simple question. What exactly is Aidan Kearney asking the judge to do? Contrary to what I've seen floating around social media, this isn't simply an 88-page rant accusing the Commonwealth of misconduct. Legally speaking, it's actually much more narrow. The defense is asking the court for 3 very specific forms of relief. Understanding those 3 requests will help make sense of everything that follows. The first request is the biggest one. Dismiss the indictments entirely. Now, dismissal is one of the most serious remedies that a judge can impose, and courts generally don't throw criminal charges out all silly-nilly just because the defendant disagrees with how a case was investigated. Judges expect investigations to be imperfect. They expect witnesses to contradict each other. They expect prosecutors and defense attorneys to view evidence differently. And this is one bitter pill for me to swallow because it's a lesson that I had to learn the hard way. Apparently, judges expect that each party will be less than honest with the truth. Dismissal is typically reserved for situations where the defense argues that something went so fundamentally wrong that the integrity of the prosecution itself has been compromised. In this motion, the defense argues exactly that. Specifically, they contend that the moral missteps impairing the prosecution's integrity occurred before the grand jury even chose to indict. The defense initially relies on Massachusetts case law that allows dismissal if prosecutors or investigators materially mislead the grand jury or otherwise undermine its ability to make an informed decision. If the judge isn't prepared to dismiss the charges outright, the defense asks for an evidentiary hearing where witnesses could testify under oath about the allegations. At this stage, the defense isn't asking the judge to decide whether Aidan is innocent. They're asking whether the process that produced these indictments was fundamentally fair. And those are 2 entirely different questions. A person can be guilty of a crime and still have charges dismissed if the legal process was seriously compromised, and likewise, a person can be completely innocent and still have a properly obtained indictment. The focus here is the process. The second request deals with discovery. If you've watched this channel for any length of time, you've heard terms like Brady evidence, exculpatory evidence, impeachment evidence, the whole nine. If the government possesses evidence that could help the defense, especially evidence that might cast doubt on the prosecution's witnesses or support the defendant's case, it generally has a constitutional obligation to disclose it. The defense argues that didn't happen here. In the motion, they remind the judge that they've repeatedly requested communications, private links, emails, and other materials that they believed were in the Commonwealth's possession. They contend that some of those materials were produced only after significant delay, while others still have not been produced at all. Starting to feel like a pattern, isn't it? As an alternative to dismissal, they ask the court to hold a hearing to determine what existed, what was disclosed, what may no longer exist, and whether the defense was prejudiced by any failures to disclose. Again, notice what they're asking. They're not asking us to assume prosecutorial misconduct. They're asking the judge to examine whether the government's disclosure obligations were met. That's a factual question that only the court can answer. The third request is probably the least familiar to people who don't spend much time around criminal litigation. The defense asks the court to remove specially appointed prosecutor Attorney Ken Mello from the case. And not just because he's unlikable, incompetent, and basically invisible. The claim is that, according to the motion, he may have become an essential witness. The claim is that he may have become an essential witness. There's an ethical violation, Rule 3.7 of the Massachusetts Rules of Professional Conduct, that generally discourages lawyers from serving as both advocate and necessary witness in the same trial. The defense argues that Mr. Mello's own communications, actions, and knowledge regarding evidence collection, witness interactions, and grand jury presentation may make him someone whose testimony could be relevant. They point out that another court has already disqualified him from prosecuting a separate Kearney case on similar grounds. Now, whether Judge Balazos agrees is another matter. Still, Prosecutor Mello may possess factual knowledge that can't simply be argued by another witness. If this is valid, it creates a potential ethical issue that the court would have to consider. Everything that we've talked about so far is just the introduction. 3 requests, the basic rights that are starting to feel more like 3 magic wishes in the Massachusetts court system. 1. Dismiss the indictments because the grand jury process was allegedly compromised. 2. Dismiss the indictments because discoverable evidence was allegedly withheld or not timely produced. Or 3. Remove the special prosecutor because the defense argues that he has become a necessary witness. Those are the destinations. The remaining 80-plus pages are the roadmap explaining how the defense believes that it gets there. Whether that roadmap ultimately convinces the judge, well, that's what we're about to explore. Don't think of this motion as 88 pages trying to prove that Aidan did not commit witness intimidation. Think of it as 88 pages arguing that the Commonwealth's conduct before, during, and after the indictment process was so mommicked up that the court should intervene before this case ever reaches a jury. Whether you agree with that argument or not, keep that framework in mind, and it will make each of the following sections easier to understand. Now that we understand what the defense is asking the judge to do, let's talk about why they believe any of this happened in the first place. If you peel back the legal citations If you ignore the footnotes, if you forget about the exhibits for just a few minutes, what you're left with is a story. The court will decide which story is more credible. Before we can evaluate the evidence, we have to understand the narrative that the defense is asking the judge to believe. And according to this motion, the genesis isn't even Aidan Kearney. Karen Reed is our Eve in Eden. The defense reminds the court that Aidan wasn't petitioning for Karen Reed's rights because he had some kind of personal relationship with her or anybody else involved. He started the way that many journalists do. He read publicly filed court documents. He reviewed exhibits. He spoke with sources. And after doing that, he came away believing that the public narrative surrounding the case didn't match what he was finding in the record. Whether you agree with that conclusion isn't really the point, but I think a lot of us heard the first iteration of John's death, that they'd been out drinking, maybe even arguing. She'd dropped him off at some cop party and somehow backed into him. And do you remember what the news initially said? That the whole thing was caught on Ring camera. Yikes, we all said. How tragic. What an awful situation. Sure sounds like manslaughter to me, at least. There was so much that we didn't know, and so much that we learned due to Aidan's relentless journalism. The defense says Aidan formed his opinions through journalism and education, not through harassment. And frankly, it's a good thing that he did because he took our collective apathy and made it personal. How many times have you heard someone say, "It could have just as easily been me. Any one of us could have been Karen Reed"? The motion describes Aidan as an independent journalist, not a traditional newspaper reporter or a television anchor, but someone whose reporting mixes investigative journalism with commentary, activism, and satire. The defense claims that's important because many of the statements now cited as quote-unquote evidence of intimidation originally occurred in long-form YouTube presentations lasting 2 or 3 hours where facts, opinions, jokes, and commentary all coexisted together. Then came April of 2023. Since you've been following the Karen Reed case, you already know that this was a pivotal month. The Reed defense filed an explosive motion. It alleged, amongst other things, that John O'Keefe may have died inside Brian Albert's home. It questioned Jennifer McCabe's Google searches. It accused investigators of overlooking or mishandling evidence. Those allegations were already in the public record before Aidan ever even wrote about them. And then, according to the motion, Aidan did what Aidan does best. He amplified those allegations. On April 18th of 2023, he published what became the first ever Canton cover-up article. The defense portrays that moment as the beginning of a completely different story. Not just the Karen Reed case anymore, but the spark that ignited a public movement. The motion spends several pages emphasizing just how influential Aidan's reporting became, similar to the way that Attorney Pyle did this past week in court when he proclaimed, "I would submit that Aidan Kearney successfully enlisted the greatest degree of public participation in a judicial proceeding in the history of this Commonwealth." It was one of those moments that kind of ripples through your soul like a breeze, or like the gentle flutter of butterfly wings. What had been a relatively local criminal case suddenly attracted national attention, and support for Karen Reed exploded. Court appearances that once drew meager or modest crowds suddenly attracted protesters, media coverage, and even international interest. The defense argues that Aidan's reporting played a substantial role in that transformation. And this is really where the motion begins laying the foundation for everything that follows, because the defense says that increasing public attention had consequences, political consequences, reputational consequences, professional consequences. According to the motion, people who had previously lived relatively private lives suddenly found themselves under enormous public scrutiny. The defense argues that the scrutiny and resulting discomfort wasn't caused solely by Aidan. It was fueled by publicly filed court documents, federal investigations, media coverage, and especially the growing public skepticism surrounding the investigation into John O'Keefe's death. Aidan became one of the loudest voices discussing those issues. He was the microphone, the megaphone, the MC. And according to the defense, that made him a problem for some of the citizens of Norfolk County. So here's the central theory this motion asks the judge to accept. They argue that certain public officials and private citizens increasingly saw Aidan as someone who needed to be stopped. It's one thing to say someone found his reporting offensive. It's another to say government power was eventually used to silence that reporting. And that is the claim being advanced here. Determining the extent of this claim is where the rest of the motion comes in, because the defense doesn't just tiptoe through the tulips. They don't stop with broad accusations. Over the next 70-plus pages, they support their thesis with emails, text messages, grand jury transcripts, discovery correspondence, and communications among investigators and prosecutors. Notice what the defense does not spend much time arguing. It doesn't spend pages trying to convince the judge that Aidan is a good person or that every article he wrote was perfect. It doesn't try to argue that his style was universally appreciated or admired. In fact, it openly acknowledges that many people hated his reporting. The defense recognizes something that I think is strategically smart. Whether people like a journalist, whether they think he's abrasive, whether they think he's funny, or even obnoxious, those aren't legal questions. Opinions are legally protected free speech, right? The legal question is whether the government responded lawfully. It's an important distinction that we sometimes forget. You can dislike someone's style, you can disagree with practically everything they say, and you can simultaneously believe that they deserve the same constitutional protections as everyone else. Likewise, you can admire someone's journalism and still believe that they crossed a legal line. Those questions aren't necessarily connected. The quality of TURTLEBOY's journalism is irrelevant. The question here is whether this prosecution was brought for lawful reasons and pursued through lawful means. So that's the framework. The defense says this case didn't begin with witness intimidation. It began with reporting, and then criticism, and then growing public pressure. Then, according to the motion, an effort to stop the criticism by silencing the critic. Everything else in this motion is offered as evidence supporting that theory. The defense isn't asking the judge to view this as an isolated witness intimidation case. It's asking the judge to zoom out, to take it to 39,000 feet. Look at everything that was happening around the Karen Read case in 2023. The federal investigation, the public protests, the collapsing public confidence, the media attention, the political pressure. And then it asks the judge one question. Was this prosecution a response to criminal conduct, or was it, as the defense alleges, part of a broader effort to stop a journalist whose reporting had exceeded inconvenient and become politically and professionally damaging. That question becomes the lens through which the defense wants the court to read every remaining page of the motion. We've reached what I think is the heart of this document. Everything that we've discussed so far has really been setting the stage. Now the defense begins laying out its timeline, a chronology. One of the oldest ways that lawyers try to persuade judges is through sequence. If enough events happen in a particular order, as the argument goes, that order may tell a story all by itself. The defense wants the judge to look at the sequence and ask a simple question. Was all of this merely a coincidence, or was something larger unfolding here? The timeline begins on April 10th, when several key figures connected to the Karen Reed case learned that they had become subjects of a federal investigation. The defense alleges that Colin Albert was served with a federal grand jury subpoena. Jennifer McCabe was also allegedly served with a subpoena and briefly interviewed by FBI agents that same morning. Remember, the FBI ice cream truck was making its way around Canton. The motion further alleges that Brian Albert, Brian Higgins, Kerry Roberts, Michael Proctor, and others would each later receive federal subpoenas as well. Now, whether federal subpoenas ultimately lead to charges is another matter. Sometimes they do, sometimes they don't. But being served with a federal subpoena is serious. It means federal investigators believe that you may possess information relevant to an active investigation. And according to the defense, that changed everything. The motion goes on to allege that Jennifer McCabe made several phone calls immediately after the FBI ice cream truck approached her. It alleges that during Karen Reed's 2025 trial, Jen McCabe admitted that she initially identified herself to the FBI as her sister Nicole before correcting herself, and that she terminated the interview after only a few minutes. And remember, by FBI, we're talking about Adam Deitch. No wonder they're such strong supporters of Greg Conner. The defense characterizes those events as evidence that key witnesses were under mounting pressure. Again, that's the defense's interpretation. The Commonwealth would almost certainly view those events differently. But remember, we don't need to decide who's right. We just need to understand why the defense believes what it believes. Then, just 2 days later, so April 12th, Karen Reed's defense files what would become one of the most consequential motions in the entire case. Since you've been following the story, you already know the document that I'm talking about. The motion alleging that John O'Keefe died inside 34 Fairview. The motion discussing the 2:27 a.m. Google search and alleging evidence destruction. The motion that fundamentally changed the public conversation surrounding the entire case. Here, April 12th is important because those allegations were no longer whispers. They were now part of the public court record. 6 days later, on April 18th, the first Canton cover-up article is published. That's going to be the date that the defense repeatedly returns to throughout the motion, because it argues that Aidan didn't invent the allegations, he just amplified the allegations that were already filed in open court. According to the defense, that's a crucial distinction. Journalists routinely report on public court filings. The defense argues that's exactly what happened here, but something else happened too. People finally started paying attention. The motion argues that support for Karen Reed expanded dramatically. Court hearings attracted larger crowds, media attention intensified, The Free Karen Reed movement gained momentum, and according to the defense, the criticism directed toward the Norfolk District Attorney's Office, the Massachusetts State Police, Jennifer McCabe, and members of the Albert family grew louder almost by the day. Whether Turtle Boy caused the movement or simply became one of its loudest voices is something that reasonable people can debate. But the defense clearly believes that his reporting became impossible for public officials to ignore. Then we move into May. The defense notes that the district attorney's office sought information from federal authorities about the ongoing federal investigation. Later that month, Jennifer McCabe sought a harassment prevention order against Aidan Kearney. Alas, the request was denied. According to the motion, McCabe also asked the court to, quote-unquote, do something so he can't blog about me. The judge declined, concluding that however upsetting the reporting may have been, it was protected by the First Amendment. Regardless of where anyone stands politically, this is one of those moments that deserves careful attention. There's a significant legal difference between speech that is upsetting and speech that is criminal. Courts all over our nation deal with that distinction every single day. The defense wants the judge to remember that distinction throughout this case. Then summer arrives, and according to the motion, the pressure continues building. The motion describes repeated complaints, repeated requests that authorities do something, repeated communications among witnesses, investigators, and prosecutors. By July, the motion alleges that District Attorney Michael Morrissey personally urged the Massachusetts Attorney General's office to prosecute Aidan Kearney for witness intimidation or civil rights violations. According to the defense, the Attorney General declined. The defense argues that is significant because, from their perspective, one prosecuting authority, a higher-ranking one at that, looked at the same situation and decided not to bring charges. Next came August. The motion describes additional communications between Jennifer McCabe, members of the Albert family, and the district attorney's office. Complaints intensified, meetings occurred, and finally, on August 25th, the decision was made to do something. A public statement followed shortly thereafter, aka Morrissey's hostage statement. The motion criticizes that statement extensively, arguing that it improperly vouched for witnesses, criticized internet reporting, and attempted to influence public perception of the Karen Reed case. Now again, this is from the perspective of the defense. Really looking forward to what the Commonwealth's perspective will be. Next, September. This is where the pace really accelerates. Protests continue, more complaints are made. D.A. Morrissey formally recuses his office. Special Prosecutor Kenneth Mello is appointed. But according to the defense, the Massachusetts State Police investigators, who had themselves become subjects of criticism, remained pretty involved in the investigation. The motion argues that this created an unresolved conflict of interest. Whether the judge ultimately agrees, we will find out. But this is the point where the defense believes the transition occurred from public controversy to criminal prosecution. So why spend nearly 15 pages walking through dates? Because the defense isn't simply saying, trust us, bro. It's inviting the judge to connect the dots. Federal subpoenas, explosive court filings, growing public attention, repeated complaints, failed efforts to stop the reporting through civil proceedings, requests that officials do something, and finally, a criminal prosecution. Now, whether those dots truly connect is one of the central questions that Judge Balazos will eventually have to answer. There's an important lesson here that extends far beyond this specific case. chronology isn't proof. Just because event A happens before event B doesn't automatically mean event A caused event B. We've all heard about how correlation is not causation. Lawyers know it, judges know it, the defense knows it, we all know it. And that's why this section isn't intended to prove the case. It's intended to establish the timeline. In the sections ahead, the defense begins introducing documents, emails, messages, and testimony that it says transform this chronology from a series of coincidences into evidence of intent. And not Aidan's intent, the Commonwealth's. If the previous section was about chronology, this one is about credibility, because after laying out its timeline, the motion introduces someone that the defense believes sits atop the mountain of what happened next. Her name is Katherine Peter. Now, before we go any further, disclaimer. Everything that we're about to discuss comes from the defense's motion, and many of these statements are allegations. Some rely on exhibits or testimony, and others rely on the defense's interpretation of the documents. The Commonwealth will undoubtedly dispute many of these claims. It's not our goal to decide who's telling the truth. Our only goal is to understand why the defense believes that Kate Peter is so important to its argument. The first thing the motion wants the judge to know is that Kate Peter was not a stranger to Aidan Kearney. As presented here, she worked for him beginning in 2018, and their working relationship ended in early 2020. The defense says Aidan terminated Kate's employment after discovering that she had been stealing from him. Whether that's accurate or not, the point the defense is making is that this wasn't a random internet critic. These were two people with history. And according to the defense, that history matters, because from this point forward, the motion portrays Kate Peter not simply as someone who disliked Aidan, but as someone who became deeply invested in opposing him. And it alleges this using remarkably strong language. It describes what it calls an unhealthy fixation. Why is the defense spending so much time on this? Because credibility is everything. If investigators rely heavily on information from a particular source, the defense naturally wants the court to know everything it believes affects that source's credibility. So the motion immediately turns to 2020. Kate Peter allegedly created forged federal court documents during a copyright dispute with YouTube. The motion claims that she modified a real complaint from an unrelated federal case, changed names and information, and presented it to YouTube as though it were an authentic lawsuit involving Aidan Kearney. Her scheme allegedly unraveled because she failed to change the original case number, leaving behind a filing that appeared to be from 2020, but still carried a 2013 docket number. The defense also points to a later online interview in which she admitted submitting the altered complaint to YouTube because she hated Aidan. The defense believes that these allegations are important. If the court concludes that someone previously fabricated evidence in an effort to harm the defendant, the defense argues that's highly relevant when evaluating later evidence that same person provides to investigators. So then we jump ahead to 2023. According to the motion, Kate Peter allegedly created another false narrative, this time involving Colin Albert and Chris Albert. The defense claims Kate Peter sent Aidan an anonymous email under the name Mia Rose. The email allegedly claimed that Colin Albert was dealing substances, that the Albert family knew about it, and that this somehow provided a motive connected to John O'Keefe's death. Fabricated screenshots allegedly accompanied the email, supposedly showing conversations involving Colin Albert. According to the defense, none of what Kate Peter said in those emails was true. Golly, if anything was defamation, it seems like that would be. Now, here's where the story becomes more complicated. The motion acknowledges that Aidan discussed the anonymous email during one of his YouTube presentations, but it also says that he repeatedly cautioned viewers that the information was unverified, that he intended to investigate it, and that after doing so, he later concluded that it was not credible. The defense argues that this wasn't someone knowingly repeating information that he believed to be false. Aidan openly treated it as an unverified tip until he could determine whether it was accurate. Then comes perhaps the most striking allegation in the entire section. The very next day, Kate Peter live streamed her own reaction. The defense says that she admitted the story was entirely fabricated. The motion quotes her describing it as 100% a fabrication out of my mind. It also alleges she acknowledged she sent it simply to mess with Aidan. Those are direct allegations contained in the motion. The defense proposes that if investigators later relied upon information supplied by someone who has already admitted fabricating evidence against the same defendant, that history of avarice becomes extremely relevant. Now the section takes another turn because, according to the motion, within just a few months, that same certain someone, KP, allegedly became one of the prosecution's most active civilian informants. The motion describes emails, private links, communications with investigators, material allegedly provided directly to members of the Massachusetts State Police. The defense contends that Kate Peter immersed herself in the investigation, cataloging Aidan's content and directing investigators toward clips she believed demonstrated criminal intent in some kind of the enemy of my enemy is my friend sort of arrangement. Here's where the motion shifts from criticizing Kate Peter to criticizing investigators. Notice the subtle change. We go from can Kate Peter be trusted to knowing what investigators allegedly knew about her history, should they have relied on her the way the defense claims they did? They point to emails, references to private links, communications with Detective Lieutenant Brian Tully and Sergeant Yuri Buchanan, and allegations that evidence supplied by Kate Peter ultimately became part of the grand jury presentation. Whether every one of those allegations proves true remains to be seen, but together they form one of the central pillars of the defense's motion. It's not for us to decide the credibility of Kate or Aidan. The real question is whether investigators sufficiently tested the credibility of every source that they relied upon. Every criminal investigation depends on human beings. Witnesses, informants, victims, complainants, critics, supporters, and human beings are notoriously unreliable. And they all bring biases. The question is whether investigators recognize it, document it, and account for it. And that's the point the defense wants the judge to keep in mind before turning the page. Up until now, the defense has spent its time talking about people, witnesses, investigators, prosecutors, timelines, motives, but in this section, the focus adjusts. Now the motion begins asking a different question, not who investigators relied upon, but how they presented evidence to the grand jury. This actually raises a question that applies to every criminal case. How much context is enough? And when does removing context change the meaning of evidence? The defense argues investigators repeatedly selected very, very short excerpts from much longer YouTube presentations and presented those tiny excerpts to the grand jury as evidence of criminal intent. According to the motion, those excerpts were often renamed, isolated from the surrounding discussion, and shown without the broader context in which they originally appeared. In reality TV, they call it frankenbiting. The defense contends that this created a misleading impression of what Aidan actually said and intended. The Commonwealth will definitely respond that prosecutors routinely introduce only the portions of recordings that they believe are legally relevant. That's not unusual at all. Trials happen that way every single day. The disagreement isn't over whether excerpts can be used, it's over whether these particular excerpts fairly represented the original presentation. That's an important distinction because editing by itself isn't misconduct. Every television news story you've ever watched was edited, every documentary, every podcast. The mighty Mark Bederow edited the Mega Motion before submitting it. Editing isn't inherently deceptive. The real question is whether the edits preserve the original meaning or alter it. And I think that's the larger lesson this section is trying to teach. Context isn't always a defense. Sometimes context makes things worse. Sometimes someone says something that sounds terrible, and the surrounding conversation only reinforces it. Last year, after the Texas floods on the 4th of July, I saw people enraged about a quote made by our governor, Greg Abbott. Based on what they were saying, that he'd called citizens seeking accountability losers, I thought, surely something was taken out of context or misquoted. I wondered if maybe it was an old video clip discussing college sports or something. Well, I tracked down the source. When a reporter asked the Texas governor who is to blame for the deaths of more than 100 people in the catastrophic Guadalupe River flooding, Greg Abbott said this.
You ask, I'm going to use your words. Who's to blame? Know this. That's the word choice of losers. Every football team makes mistakes. The losing teams are the ones that try to point out who's to blame. The championship teams are the ones that say, don't worry about it, man. We got this. We're going to make sure that we go score again, that we're going to win this game. The way winners talk is not to point fingers. They talk about solutions. What Texas is all about is solutions.
Until that day, I didn't really have a strong opinion about him one way or another. But nobody should speak to families whose 7-year-old daughters were missing or dead as if this was just a lost football game pep rally. In this case, context definitely made it worse. However, other times, context completely changes how reasonable people understand a statement. And that's why context matters. The defense then walks through several examples. Investigators selected portions of presentations discussing witnesses, public officials, and the Karen Reed investigation, while omitting other portions in which Aidan allegedly reminded viewers not to harass anyone, or where he distinguished opinion from fact, or where he acknowledged uncertainty. The defense argues that those omitted statements were essential to understanding his intent. Without them, the excerpts sounded much more sinister than the complete presentations in context. The prosecution will likely respond that the omitted material didn't change the legal significance of the statements that were shown. That's ultimately something that the court will have to evaluate. Another point that the defense raises involves the file names. Investigators allegedly assigned descriptive titles to the video clips before presenting them. The defense argues those titles were not neutral labels. It contends they reflected conclusions about Aidan's intent before the evidence had even been considered by the grand jury. I think we can expect the prosecutors to argue that grand juries aren't expected to watch dozens of hours of live streams. that their job is to decide whether probable cause exists, not to resolve every factual dispute. And from that perspective, showing selected excerpts isn't necessarily unfair. It is practical. The defense, on the other hand, argues that if the selected excerpts materially altered the meaning of what was actually said, then practicality becomes something else. It becomes misleading. And therein lies the disagreement. So, this section isn't really asking us to decide whether Aidan's speech was offensive or inflammatory or sarcastic or irresponsible. It's asking something much more fundamental. When the government presents evidence to a grand jury, how much responsibility does it have to preserve the original meaning of that evidence? That's a question that reaches far beyond this case. Every one of us has probably had the experience of saying something only to hear someone repeat it later out of context, and sometimes it's harmless, sometimes it's embarrassing, sometimes it completely changes what we meant. The law doesn't require perfect communication, but it does expect honesty in how evidence is presented, and that's the principle the defense says was violated here. So, we've talked about the people involved, we've talked about the timeline and the edited videos presented to the grand jury, but none of those issues can be evaluated fairly unless both sides have access to the evidence. And that brings us to discovery. Brady evidence is information held by the prosecution that could help the accused. It might directly support innocence, or it might weaken part of the government's theory, or it might show that an important prosecution witness has a reason to lie. The name comes from a court case, but the principle is simple. The government is not supposed to play hide and seek with evidence that could make a. There's another word that you'll see in this motion. It's spelled Giglio. I have heard it pronounced so many different ways. I've heard it pronounced giglio, and I think that you guys actually taught me that the proper pronunciation is Giglio, like Zsa Gabor, Giglio. Giglio evidence is closely related, but it focuses especially on witness credibility. Suppose the government's star witness says, "I have no reason to dislike the defendant." But prosecutors possess emails showing that this witness has spent 3 solid years trying to get the defendant fired, arrested, and removed from the internet. Those emails may not prove the defendant is innocent, but they sure could help the defense show that the witness has a motive, a bias, or a personal agenda. That is the kind of information the defense says must be disclosed. And then there is something called automatic discovery. This is the material the rules already require the prosecution to provide. The defense shouldn't have to guess that it exists. It shouldn't need to stumble across it accidentally in somebody else's FOIA request. And it shouldn't have to ask the same question over and over again. So, what does Aidan Kearney's defense say happened here? According to the motion, the defense began making formal demands for evidence back in February of 2024. That was right after Aidan was released from jail, wasn't it? It requested witness statements, communications among civilians and investigators, videos, reports, and other materials covered by the Massachusetts discovery rules. I guess the defense received something, but not much, because the following month they told the Commonwealth that its response was inadequate. And then on April 23rd of 2024, the judge ordered that the prosecution provide all automatic discovery by May 8th of 2024. The motion alleges that the deadline was not met. It also says that specially appointed prosecutor attorney Robert Cosgrove later acknowledged that Ken Mello had impeded progress on discovery, although some materials were eventually produced. Now, missing a deadline doesn't automatically mean that someone deliberately concealed evidence. Court cases are messy, files can be enormous. Agencies might store records in different systems. One prosecutor might mistakenly believe another agency has already produced something. Sometimes discovery failures are negligence, or they're technical or administrative. And sometimes the parties just generally disagree about whether a particular item must be disclosed or not. So the existence of a delay by itself doesn't prove bad faith. But the defense argues that this was not just one missed deadline. It describes repeated demands stretching across many months. Beginning in the fall of 2024, the defense says it specifically requested evidence concerning Kate Peters' relationship with investigators and prosecutors, and that no responsive KP-related material was disclosed until July of 2025. That was after the court had already ruled on an earlier motion to dismiss. That timing is central to the defense's complaint. Imagine being required to write a final research paper. You ask the school for the records that you believe are important, and you're told, either directly or indirectly, that you have what you need. You write the paper, you turn in the paper, the teacher grades it. And then, months later, you receive a box full of documents that could have changed your entire argument. The question isn't merely, did you eventually get the documents? The question is, did you receive them at a time when you could actually use them? The motion says communications among Kate Peter, Ken Mello, and Detective Lieutenant Brian Tully had been in the Commonwealth's possession since 2023. It says the defense specifically requested that evidence in September and October of 2024. Remember that series of letters by Attorney Bederow? I actually have an entire playlist of them that I can link in the show notes if it would be a helpful refresher for you. So according to the filing, Mello forwarded some of the communications to Cosgrove in December of 2024, but the defense didn't receive them until July of 2025. And by then, the judge had already decided the first dismissal motion. Again, these are allegations, but here's why the defense believes they're important. Those communications allegedly reveal more about how Kate Peters supplied material to the prosecution. They may help establish whether investigators knew about her history with Aidan. They may show who accessed private links. They may help identify the source of evidence later presented to the grand jury. And they may affect the credibility of testimony about how that evidence was obtained. The motion also describes a production of nearly 5,000 pages of Detective Tully's emails. According to the defense, over 4,000 of those pages were blank. The prosecution later supplied another file containing at least some of the previously blank emails, but not 5,000 pages worth. At first, the number of pages sounds impressive, but the practical value is almost nothing. That doesn't necessarily mean that they intentionally printed blank pages. Could be an export problem or formatting error, some sort of technical failure. But until somebody explains what happened, the person receiving those files is entitled to ask whether the production was actually meaningful. Then we reach the private links. The defense says Kate Peters sent private video links and other material to members of the prosecution team. The Commonwealth reportedly argued that Detective Tully did not click unsolicited links sent by KP, and instead, he may have gone online independently to locate the content. Can you picture Brian Tully watching 3 hours of Aidan every Tuesday and Saturday? Can you picture him subscribing to Turtle Club so that he can tune in on Thursday nights? Can you picture him watching Bus Stop Lives 5 days a week? Stop it. Or as Wordle might say, pshaw. The prosecutor represented that Tully never accessed the linked materials later introduced to the grand jury, and the defense disputes that claim. They point to evidence demonstrating that Peter directed Tully toward particular content and that Ken Mello himself opened at least some private links and forwarded material to Tully for review. If Tully and Mello really did the work themselves, wouldn't you expect them to have stacks and stacks of notebooks filled with handwritten notes or some sort of documentation to support their claim of such zealous pursuit? I haven't seen anything like that come across in Discovery, have you? Maybe it sounds like we're being petty here. Did he click the link? Did he search for the video separately? Did someone else open it? Why does it matter? Well, it matters because the source and handling of evidence are part of its history. Suppose somebody emails you a private video and you watch it, and then you find what appears to be the same video somewhere else. Download it, rename it, place it in a folder. The defense may reasonably want to know whether the second file truly matches the first one. Was anything changed or omitted? Did the private version contain additional content? Who created it? Who controlled it? And is the original still available for comparison? The Commonwealth says that some of the private links are now dead because the mysterious person who created them or sent them removed the underlying material. The defense's response is essentially, the evidence was once received by agents of the government. Once the prosecution team possesses it, the defense argues, its disclosure obligations have already been triggered. The filing contends that the government cannot avoid those obligations merely because the original sender later deleted the content, whomever that mysterious original sender may be. That is a kind of prejudice the defense says occurred here, and prejudice is an essential word. A discovery mistake does not automatically mean that a case gets dismissed. Golly, if it did, Karen Reed's case would have been dismissed long before that first trial ever started. The defense usually still needs to explain why the missing or delayed evidence matters, and how did it affect the ability to investigate? How did it affect a previous hearing? Could it have been used to challenge a witness? Could it have changed how the grand jury presentation was evaluated? Could the damage still be repaired? The motion says that the delayed or missing evidence prevented the defense from fully developing its argument that the investigators relied on an unvetted source with a personal motive and a history of allegedly fabricating material against Aidan. It also argues that the undisclosed communications could have been used to challenge claims about whether Kate Peters' private links were reviewed and whether her assistance affected the edited evidence shown to the grand jury. Of course, it's never that straightforward, right? Did Kenneth Mello communicate personal factual knowledge through his questions or comments before the grand jury? Did he improperly vouch for witnesses? Did he supply his own opinions about Aidan's intent? And are those disputed events significant enough that Mello himself must testify? Here's where I ultimately land. Based on this motion alone, I can't tell you that the charges absolutely must be dismissed or promise you that they will be dismissed. A motion is advocacy. It selects facts, it frames them, it presents them in the defense's strongest interpretation. We have not yet heard the Commonwealth's complete response, and allegations, no matter how detailed, are not findings. But I also do not believe that this motion can responsibly be dismissed as just noise. It identifies specific communications, specific delays, specific files, specific grand jury testimony, specific evidence that allegedly disappeared, and specific conduct by the prosecutor himself. Those claims are testable. That's the distinction I keep returning to. Not every accusation in this motion will necessarily survive scrutiny, but enough of them appear capable of being verified or disproved that scrutiny, like true, fair scrutiny, is exactly what they deserve. This case has always lived at the nexus of speech and power. The right to criticize public officials is not unlimited immunity from criminal law. A journalist cannot transform intimidation into protected speech merely by calling it reporting, but government officials can't transform protected criticism into intimidation merely because it's aggressive, humiliating, disruptive, or politically damaging, especially when so much relies on the notion that petitioning the government is protected speech. The line matters. When the government prosecutes someone for crossing that line, the government's own conduct must remain on the correct side of it. That means presenting evidence honestly, preserving relevant material, disclosing information that may help the accused, and doing so in a timely manner, separating an investigator's labels from a defendant's words, and ensuring that a prosecutor arguing the case has not become a witness inside of it. The motion isn't proof that Aidan Kearney was prosecuted solely to silence him, nor was it ever marketed as one. It is not a judicial finding that investigators fabricated evidence, and it doesn't establish that every missing document was intentionally withheld. But it does raise serious enough questions that I believe the public deserves more than a procedural shrug. The defense has told its story. The Commonwealth must now answer it. And the court's responsibility is not to choose the more likable storyteller. It is to determine what the evidence actually shows. And that's what due process means. Not special treatment for Aidan Kearney, not automatic deference to the Commonwealth, a process capable of testing both. So now we wait to see whether the court will test it and what Judge Balazos will find. Do you think that he'll dismiss Aidan's case, or are we heading to trial in December? Please let me know your thoughts in the comments, and please double check that you're subscribed. I've had a few people reach out and ask if I've blocked them or somehow unsubscribed them. I'm not even sure if that's possible, but I can promise you that if it is possible, I would be the last person to figure out how to do such a complex maneuver. So it'll definitely help if you double check on your end. I have so many ideas in progress on the horizon, but I have fallen out of favor with the gods of the YouTube algorithm because I couldn't keep up with making weekly videos. So your likes, your comments, your hypes, and your shares are 10 times as valuable here as they might be elsewhere. And also, your feedback does matter to me. So until the next one, take care of yourself, take care of each other, and take care of our community. I love you.